From the SP Productions in Downey, California, Miguel Sanchez, Christian Romero, reporting for WHOOSH News.
Good morning, America, and welcome to the special spring break edition of WHOOSH News. In today's broadcast, we're presenting a special report on racial discrimination.
As you may know, the struggle for racial equality has been present throughout the birth of America. Its progress through the ages some might describe as exponential.
But some critics say that racial discrimination still exists in one form or another. It may be closer to home than one may think.
Which brings up the questions.
Are there sufficient laws and limitations to protect against racial discrimination? So, what limitations are there to current law? What forms of discrimination are people protected from, and what is not considered discrimination in the eyes of the court? What protection does a person have from government interference? So, what can the government do, and what are the limits of its powers?
And here are our correspondents with the report.
What can the government do toward racial discrimination? The government is allowed to protect the people from racial discrimination by placing laws and regulations. Various laws and regulations that are enforced in order to protect the people are the Civil Rights Act of 1964 and the Fair Housing Act. Both acts that were previously stated prohibit employers, realtors, creditors, and employees to discriminate against an individual based on their race, color, religion, sex, national origin, or age. The Civil Rights Act of 1964 states, "No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance," which is applicable to the way the systems of education and employment work. Educational facilities that respond to the Civil Rights Act of 1964 are primarily public schools, such as high schools and universities. Under the requirements of the Title VI of the Civil Rights Act of 1964, as long as they are receiving federal financial assistance, they are required to not enforce discrimination. Programs within the universities, such as admissions, recruitments, financial aid, academic programs, student treatment services, and etc., must operate in a non-discriminatory manner. An example of a court case which violated the Civil Rights Act of 1964 was the University of California versus Bake, 1978. A 35-year-old man named Alan Bake had applied to UC Davis Medical School seeking for admission. After being rejected twice, Bake's qualifications exceeded any minority student that was accepted, while he was rejected. With such high qualifications, Bake then claimed that the reasons for his rejections were because of his race. The court then ruled that any racial quota system supported by the government violated the Civil Rights Act of 1964. They also stated that the use of racial quotas at the school violated the Equal Protection Clause of the 14th Amendment, therefore forcing the medical school to grant Bake admission into the program.
While limits to the freedom have been established by the Supreme Court as acceptable, one such freedom that has limits is the protection from job discrimination. One example of racial discrimination are employers institute hiring practices or workplace policies that single out certain races. Another example is employers ask questions about a prospective employee's race. In the Supreme Court case, Vance versus Ball State University, centered an African-American woman named Marietta Vance, who said she was harassed and subject to racial slurs during her time as a caterer at the college. The court ruled, however, that the harasser did not have the ability to injure Vance's employment, making that person a coworker instead of a supervisor. The university and any other workplace are liable in discrimination lawsuits only if the person being harassed notifies the employer of the discrimination and nothing is done to stop it.
The Fair Housing Act is considered to be one of the most important functions of federal fair housing laws, which prevents racial discrimination in the rental sale and financing of apartments and houses. The Act states that property owners, financial institutions, and landlords may not discriminate on the basis of race and national origin to rent, sale, negotiate, make unavailable, or different terms for certain individuals. An example of a court case which violated the Fair Housing Act was Shelley versus Kramer. The Kramers were a white couple that owned a residence in a Missouri neighborhood. This neighborhood was governed by a restrictive covenant, which prevented blacks from owning a property in this area. The Shelleys, who happened to be a black couple, later moved into the neighborhood and were then brought to the court against the Kramers. The court decided that the state could not prevent the sale of property to a couple that happened to be black. Their enforcement did violate the 14th Amendment, therefore causing the Kramers to lose the case. What are the limits of power? The limits of power of the government are that even with passed laws and set regulations to prohibit racial discrimination, it is still occurring. All individuals in the U.S. are protected by the 5th and 14th Amendment, which still happen to protect an individual's rights and guarantees equal protection of the laws, including the individuals who are discriminated against others. What forms of discrimination are people protected from? Forms of discrimination in which the people are protected from are one's race, color, and national origin. According to Title VI of the Civil Rights Act of 1964, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Other protections which protect the people include recruiting, hiring, and advancement jobs, compensation and other employment terms, conditions and privileges, harassment, retaliation, and segregation and classification of employees. What is not considered discrimination in the eyes of the court? In the eyes of the court, there are a couple of things an individual may do or say that would not be considered as forms of discrimination. Specifically under the Racial Discrimination Act, artistic works or performances, statements, publications, discussions, debates, fair and accurate reports, or simply one's genuine beliefs are not considered to be forms of discrimination. As long as these actions are being done reasonably and in good faith, the court does not consider it as discrimination.
So that concludes our special spring break edition on racial discrimination.
Signing off, I'm Christian Romero.
And I'm Miguel Sanchez.
Till next time for
The
WHOOSH News.
and
Alright.
action.
Good morning, America, and welcome to the special spring break edition of WHOOSH News. In today's broadcast, we're presenting a special report on racial discrimination.
As you may know, the struggle for racial equality has been present throughout the birth of America. Its progress through the ages some might describe as exponential.
But some critics say that racial discrimination still exists in one form or another. It may be... Louis, stop!
Oh shit, hey, the thing's in the camera.
Okay. Just keep going. Alright.
Let's do it again. Louis, don't do anything.
3.
2, 3.
Till next time for
No, that's it. The WHOOSH News. That's it.
No, wait, no, you need to go more lower. I can see your lower back.
The
WHOOSH News.
Am I supposed to get you guys jumping in?
Oh my god! You're a dick.